Hello, Realty One Group agents. Tim is back with page 7 of the RPA. There's nothing on this page to really fill out other than paragraph 22, but let me read through what we have. Instructions to escrow. Paragraph 20, escrow. If this agreement or any matter relating here to shall become the subject of any litigation or controversy, buyer and seller agree jointly and severally to hold escrow holder free and harmless from any loss or expense except losses or expenses that may arise from the escrow officer's negligence or willful misconduct. If conflicting demands are made or notices served upon escrow holder with respect to this agreement, the parties expressly agree that escrow is entitled to file a suit in interpleader and obtain an order from the court authorizing escrow holder to deposit all such documents and monies with the court, and obtain an order from the court requiring the parties to interplead and litigate their several claims and rights among themselves. Upon the entry of an order authorizing such interpleader, escrow holder shall be fully released and discharged from any obligations imposed upon this agreement, and escrow holder shall not be liable for the insufficiency and correctness as to form, manner, execution, or validity of any instrument deposited within, nor as to the identity, authority, or rights of any person executing such instrument, nor for failure of buyer and seller to comply with any of the provisions of any agreement, contract, or any other instrument filed by the escrow holder or referred to herein. Escrow holder's duties hereunder shall be limited to the safekeeping of all monies, instruments, and other documents received by it as escrow holder, and for disposition in accordance with the terms of this agreement. In the event an action is instituted in connection with escrow, in which escrow holder is named as a party or otherwise compelled to make an appearance, all costs, expenses, attorney fees, and judgment escrow holder may extend or incur in said action shall be responsibility of the parties hereto. Wow. Paragraph 21. Unclaimed funds. In the event that the funds for this transaction remain in an account held by escrow holder for such period of time that are deemed abandoned under the provisions of Chapter 120A of the Nevada Revised Statutes, escrow holder is authorized to impose charge upon dormant escrow account. Said charge shall be no less than $5 per month and may exceed the highest rate of permitted by statute or regulation. Escrow holder is further authorized and directed to deduct the charge from the dormant escrow account for as long as the funds are held by the escrow holder. Basically, this is to protect the escrow company. If the buyer and seller start suing each other, the escrow company, the title officer, the title and escrow company are not involved in a lawsuit unless they are found to have done something wrong, where they misinterpreted something, they had some sort of negligence or misconduct. Otherwise, escrow is held harmless from any of these things. And number 21 comes into play is when an RPA is canceled. If the buyer and seller do not sign a cancellation, that money is held by the title company for an indefinite period of time. It could sit at escrow for weeks, sometimes months, until the parties both either compromise on the distribution of that money, or it'll just sit there. And if it sits there usually more than 90 days, that's when the title company can charge $5 to the account. Okay? Now, brokers. Let's scroll up here a little bit, gang. Section 22. Brokers' compensation and fees. This is what we call our transaction fee, gang. Buyer herein requires, the seller agrees, as a condition of this agreement per Section 2, the seller will be paying listing broker and buyer's broker, who becomes by this clause a third-party beneficiary to the agreement, a certain sum or percentage of the... Sorry, gang, lost my spot. I was overthinking things here. That the seller or seller's broker offered for the procurement of ready, willing, and able buyer per the RPA. Seller understands and agrees that if the seller defaults hereon, the buyer's broker is a third-party beneficiary of this agreement, has the right to pursue all legal recourse against the seller for any commission due. In addition to any amount due to the buyer's broker from the seller or seller's broker, the buyer will or the buyer will not pay buyer's broker additional compensation in the amount determined between the buyer and the buyer's broker. So this is where, gang, very important. Paragraph 22. 99 out of 100 times you're going to check off the buyer will. That means the buyer will be paying your transaction fee, which is $200 per 200,000 of the sales price. If you're not sure about how to calculate that, go back to your manager, okay? But you can check off will not pay the buyer's broker. Now, if you do that, that's okay, but that means you're paying it out of your commission. on line 33. So that's very, very important. Line 33 is where you're going to will or will not. Paragraph 23, hold harmless and waiver of claims. Buyer and seller agree that they are not relying upon any representations made by the buyer's broker or broker's agent. Buyer acknowledges that at close of escrow, the property will be sold as is, whereas without any representations or warranties, unless expressly stated therein. Buyer agrees to satisfy himself or herself as to the condition of the property prior to close of escrow. Buyer acknowledges that any statements of acreage or square footage by the broker are simply estimates, and the buyer agrees to make such measurements as buyer deems necessary to ascertain actual acreage or square footage. Buyer waives all claims against the brokerage or their agents for A, defects in the property, B, inaccurate estimates of acreage or square footage, C, environmental waste or hazards on the property, D, the fact that the property may be in a flood zone, E, the property's proximity to freeways, airports, and nuisances, F, the zoning of the property, G, tax consequences, or H, factors related to the buyer's failure to conduct walkthroughs or inspections. Buyer assumes full responsibility for the foregoing and agrees to conduct such tests, walkthroughs, inspections, and research as buyer deems necessary. In any event, broker's liability is limited under any and all circumstances to the amount of the broker's commission fee received in the transaction. So basically, paragraph 23 says you're going to make sure your buyer does any and all inspections that they want to. And after they do those inspections and they sign on the dotted line, they can't necessarily come back to you as the agent and file suit because they've had all these inspections done. And if they do, like it says on line 44, in any event, the broker's liability is limited to, under any and all circumstances, to the broker's commission. So that's important that you know that, okay? And paragraph 24, other matters, definitions, acceptance. Definitions, acceptance means the date that both parties have consented to a final binding contract by fixing their signatures to this agreement, and all counteroffers, and said agreement and all counteroffers have been delivered to both parties pursuant to section 25 herein. Agent means a licensee working under a broker or licensees working under a developer. Agreement includes this document as well as all accepted counteroffers and addenda. Appraisal means a written appraisal in which a written appraisal or notice of value as required by any lending institution prepared by a licensed or certified professional. Again, this is at the end of each page. Each party acknowledges that he or she has read, understood, and agrees to each of these provisions on this page unless a particular paragraph is otherwise modified or addendum or counteroffer. Buyer's signature, buyer's initials, property address, seller's signature. Stay tuned for page 8. Realty One Group agents, it's Tim again. We're continuing in page 8, which at the end of page 7 was definitions. Bonafide means genuine. Buyer means one or more individuals or an entity that intends to purchase the property. Broker means the Nevada licensed real estate broker listed herein representing seller and or buyer and all real estate agents associated therewith. Business day excludes Saturdays, Sundays, and legal holidays. Calendar day means a calendar day from/to midnight unless otherwise specified. CFR means Code of Federal Regulations. CIC means Common Interest Community, formerly known as HOA or Homeowners Associations. We typically always say HOA, gang. We very seldom use CIC. CIC capital contribution means one-time non-administrative fee, cost or assessment charged by the CIC upon change of ownership. CIC transfer fees means the administrative service fee charged by the CIC to transfer ownership records. Close of escrow or COE means the time of recordation of the deed in the buyer's name. Default means the failure of a party to observe or perform any of its material obligations under this agreement. Delivered means personally delivered to parties or prospective agents, transmitted by facsimile machines, electronic means, overnight delivery, or mailed by regular mail. Down payment is purchase price less loan amount. EMD means buyer's earnest money deposit. Escrow holder means the neutral party that will handle the closing. FHA is the U.S. Federal Housing Administration. GLVAR means the Greater Las Vegas Association of Realtors. Good funds means an acceptable form of payment determined by the escrow holder in accordance with NRS 645A.171. IRC means the Internal Revenue Code, parentheses tax code. LID means Limited Improvement District. NA means not applicable. NAC means Nevada Administrative Code. NRS means Nevada Revised Statutes as amended. Party or parties means the buyer and the seller. PITI means principal, interest, taxes, and hazard insurance. PMI means private mortgage insurance. PSD means specific standard time and includes daylight savings, and if in effect on that date. PTR means preliminary title report. Property means the real property and any personal property included in the sale of the property herein. Receipt means, what does it mean, Tim? Receipt means delivery to the party or the party's agent. RPA means residential purchase agreement. Seller means the one or more individuals or the entity that is the owner of the property. SID means special improvement district. Title company means the company that will provide title insurance. USC is the United States Code. VA is Veterans Administration. That's a mouthful, gang. Paragraph 25, signature, delivery, and notices. This agreement may be signed by the parties on more than one copy, which, when taken together, each signed copy shall be read as one complete form. This agreement and documents related to any resulting transaction may be signed by all parties manually or digitally. Facsimile signatures may be accepted as original. B. When a party wishes to provide notice as required to this agreement, such a notice shall be sent regular mail, personal delivery, overnight delivery, by facsimile, and or by electronic transmission to an agent for that party. The notification shall be in effect when postmarked, received, faxed, delivered, delivery confirmed, and or read receipt confirmed, in this case of an email. Delivery of all instruments or documents associated with this agreement shall be delivered to the agent or seller if represented. Any cancellation notice shall be contemporaneously delivered to the escrow in the same manner. Paragraph 26. IRC 1031 exchange. The seller and or buyer may make this transaction part of IRC 1031 exchange. The party electing to make this transaction part of the IRC exchange will pay an additional expense associated therein at no cost to the other party. The other party agrees to execute any and all documents necessary to effectuate such an exchange. 27. HUD, VA, FHA escape clause. This is important. It is expressly agreed that, notwithstanding any other provision of this contract, the purchaser shall not be obligated to complete the purchase of the property described herein or incur any penalty by forfeiture of earnest money or otherwise unless the purchase has been given in accordance with HUD, FHA, or VA requirements, a written statement issued by the Federal Housing Commissioner, Department of Veterans Affairs, or direct endorsement lender, setting forth the appraised value of the property of not less than the agreed upon contract purchase price. The purchaser shall, however, have the privilege and option of proceeding with the consummation of the contract without regard to the amount of the appraised valuation. The appraised valuation is arrived at to determine the maximum mortgage of the Department of Housing and Urban Development, will ensure or percent the Department of Veterans Affairs will guarantee HUD, FHA, and VA loans does not warrant the value of the condition of the property. The purchaser shall satisfy herself that the price and the condition of the property are acceptable. In other words, if you have a VA buyer and FHA buyer, and the loan and the appraisal comes in for $300,000, but your purchase price is $325,000, and you cannot come to an agreement between the buyer and the seller with that $25,000 difference, the buyer can cancel and get all their money back. That's basically what it means. It's an escape clause for government-backed loans, FHA or VA loans, okay? So if you have any questions about that, go see your manager. Number 28, other essential terms. Time is of the essence. No change, modification, or amendment of this agreement shall be valid or binding unless such change, modification, or amendment shall be in writing and signed by each party. This agreement will be binding upon their heirs, beneficiaries, devisees, and party hereto. The agreement is executed, intended to be performed in the state of Nevada, and the laws of that state shall govern the interpretation and effect. The parties agree that the county and state in which the property is located is the appropriate form for any action relating to this agreement. Should any party, my mouse is going crazy again, bear with me. Should any party herein retain counsel to the purpose of initiating litigation to enforce and prevent the breach of any provision hereof, or for any other judicial remedy, then the prevailing party shall be entitled to be reimbursed by the losing party for all costs and expenses incurred thereby, including but not limited to reasonable attorney fees and costs incurred by such prevailing party. Again, at the end of every page, each party acknowledges that he or she has read, understood, and agrees to each and every provision on this page, and unless a particular paragraph is otherwise modified by addendum or counter offer. Buyer's name, property address, buyer's initials, seller's initials. All right, gang, stay tuned for page 9.